Good evening, everyone. I want to thank you so much for joining us for this 2020 Rapid Implementation webinar series. Tonight, our series is COVID-19 Staffing Q&A for Physicians, and done in collaboration with the law firm of Paley, Rothman. We want to remind you that this call is being recorded, and we will post it online for our practices to access this week. We will begin recording this call now. My name is Susan D'Antoni, MCMS Executive Director, and I wanted to share a few housekeeping items before we begin. We will mute participants at the beginning of the call for sound quality purposes. To mute or unmute yourself over the phone, press *6. On a PC, Alt+A. On a Mac, Shift plus Command plus A. We welcome your questions. You can submit them via the chat feature. As our social and legal environments continue to change in response to COVID-19, physicians in particular are facing a number of complicated and very difficult employee management issues. This Q&A session is based on questions submitted in advance by our physician attendees today. We are joined by attorneys David Shapiro and Jim Hammerschmidt of the law firm of Paley Rothman, based in Bethesda. Jim and David have years of experience working with healthcare practices and physicians and employers in general, and will provide a 10-minute update on new and existing laws impacting Montgomery County-based employers, as well as try to navigate this new world dealing with COVID-19 related laws and business issues, followed by Q&A. David?
Thank you, Susan. I'm going to see if I can share my screen here. And we'll bring up our slide deck. Hopefully that works for everyone. So yeah, again, thank you, Susan, Chris, and Alex for asking Jim and I to join you again tonight. We have a pretty quick update that we're going to try to scroll through here. Hopefully, people have attended some of the other programs that have been put on through the Montgomery County Medical Society, so a lot of this will be review, but there are some updates that have come out in the last few weeks, certainly since the last time we spoke with you. So our goals are to go through fairly quickly. If there are questions, again, please do enter them in the chat box, and we will try to get to them as quickly and as effectively as we can at the end. But after that, we want to take a look at the updates on the FFCRA, the Families First Coronavirus Response Act, some changes that have come out with return to work guidelines, which seem to be the bulk of the questions. And then we do have questions that were submitted in advance. We'll go through those, and then we'll aim to take whatever questions that we can out of the chat, okay? So let's jump right into it. The Families First Coronavirus Response Act, what we're going to call the FFCRA, was signed back in March of this year. It was effective April 1st, and it runs through the end of the year. That's important to remember because time is ticking away on this. Ultimately, this impacted businesses in 4 key ways, really 3, but the last one touched on some issues that some of our clients had. It required some employers to provide paid and medical leave above what they would normally have to here in Montgomery County. It required some employers to provide paid sick leave, again, beyond what we would normally have to. It provided tax credits for employers to recover some of the costs that they incurred paying out the mandated leave. And then that third piece was unemployment benefits that were provided for employees. Now that under the unemployment that was offered under the FFCRA did come to an end, but it has since been replaced by a memorandum which took the look of an executive order from the White House, which ultimately said that the federal government is still going to pay a $300 supplement, and they are encouraging states to pay an additional $100. Maryland has agreed to do that, so there would be a $400 benefit paid under that executive order. The FFCRA really impacted most of our clients and probably most of you in 2 key ways. One was the Emergency Family Medical Leave Expansion Act. That's what we refer to when we have this EFMLEA. And also a new federal paid sick leave law. Jim and I are going to break that down quickly. The EFMLEA deals with almost everybody on this call, certainly most of our clients, and that's employers with fewer than 500 employees. In order to receive a benefit from it, the employee has to be employed for 30 days. Ultimately, this really only covers one key area, and that is when an employee needs leave due to a school or child care closure. If that situation occurs, and if it hasn't already, it looks like it may be coming up again this fall, the employee ultimately is entitled to 12 weeks of leave. The first 10 days of that may be unpaid, but do keep in mind that depends on whether or not the employee has other leave that they can tap into. When that leave has run out or the 10 days has run out, the leave would be paid at 2/3 of the employee's regular pay rate. However, it's capped. It's capped at $200 per day per employee, up to a maximum of $10,000. So these can be fairly significant costs. Businesses with fewer than 50 employees can apply for an exemption. The standard exemption that people give is that complying with the laws would jeopardize the viability of the business as a going concern. But it also provides some exemption from civil actions that your employees may bring, claiming that you violated the EFMLEA. One of the other changes is that usually what we would think of as a reinstatement requirement, if the employee has fewer than 25 employees, this is different than the Family's Medical Leave Act, which generally requires employers to reinstate employees to the same job or an equivalent position when they come back. If the employer has fewer than 25 employees, there may be an exception for having to reinstate the employee if the position no longer exists at all due to economic conditions or operational changes resulting from COVID-19. So the other practical consideration that we want to flag is don't forget that your employees may have other rights beyond the leave that comes up under FMLEA. So if an employee is looking for time off and they have accrued vacation leave, or they otherwise may qualify for leave under either Maryland or the local sick and safe type leave laws, don't forget that you still have to comply with those. Now let's take a quick look at the paid sick leave law. Jim?
Yeah, thanks, David. So as David said, the second component of the act is this paid sick leave law, and covers the same group of employers, those with 500 or fewer employees, but it entitles an employee to take leave for a wide variety of COVID-related reasons, and the leave can be up to 80 hours of paid sick leave for an employee who's subject to federal, state, or local quarantine order related to COVID, has been advised by a healthcare provider, his or her own doctor, to self-quarantine, is experiencing COVID-related symptoms, is caring for an individual who is experiencing symptoms or subject to a quarantine or isolation order, is caring for a child whose school or place of business or place of childcare is closed for reasons related to COVID, or the final catch-all is experiencing any other similarly situated condition. So this unlike what David was talking about, which is up to 12 weeks of this Emergency Family Medical Leave Act, this is 80 hours, or generally speaking, 2 weeks of paid sick leave for a wide variety of purposes. And you'll notice one of those purposes is the same as the one David was talking about, and that's number 5. So when David was saying that an employee could take up to 12 weeks and the first 2 being unpaid, this paid sick leave would fill that gap. So what you're actually going to get is an employee, if their child cannot go to school because of a school closure, or can't receive daycare because of a daycare closure, this will provide the first 2 weeks of paid leave. And then what David was talking about, the Emergency Family Medical Leave Expansion Act, will provide the remaining 10 weeks. So with respect to number 5, the employees can actually combine the 2 to get the full 12 weeks of paid leave. Right. Just like the expanded Family Medical Leave Act that David was talking about, there are caps on how much an employee can be paid for this leave. If it's related to his or her own condition, that's suffering from a COVID-related symptoms or quarantine or isolation, the employee can receive up to $511 per day and as a cap, and $5,110 per employee. If the employee is taking care of someone else or is staying home to take care of a child whose school or daycare is closed, then it's $200 per day with a maximum $2,000 per employee for that 80 hours. And again, there's an exemption for employers with fewer than 50 employees if they can show that the leave would jeopardize the viability of the business as an ongoing concern. I have counseled 50 to 100 or more clients. I'm not aware of anyone who has yet taken the position that they are exempt. The hurdle is fairly high. So what has happened? That was the law passed in March, as David discussed. What has happened since that time? First of all, there were many, many questions that employers had on the implementation of this. It was Byzantine, it was difficult, there were gaps, there were all kinds of questions that were raised, uncertainties. And over time, the Department of Labor has developed an FAQ to try to flesh some of that out. And we put the link here because, frankly, I think it's invaluable. I'm going looking at the link and looking at the frequently asked questions several times a week because there are 97 of them. But they generally, at this point, will answer just about any question that you can have about these two pieces of leave and how they may affect questions that you have with respect to your employees. So I find it to be a very valuable source. The things that we're coming up on now, as David said, are school closures and daycare issues. With respect to school closures in particular, there are valuable facts on that Department of Labor website. They've updated them in the last month to deal specifically with school closure issues. School closures, an employee can be eligible for either of these types of leave under school closure if another suitable individual or usual child care provider is unavailable. So, for example, if the mother works and the husband is usually a child care provider, if he is unable for whatever reason to take care of the children due to a closure, then the individual would apply. Same thing if typically the grandparents might provide child care. And this is really on an honor system. So as an employer, it's hard to root out any misrepresentations in this area, let's call it, and you really have to go on the honor system with your employees, and hopefully they're honest. The physical location of the child's school or daycare must be closed. So if the daycare or school is open, but the parent is choosing to homeschool their children because of an anxiety or concern about COVID, they would not be eligible to take leave. We're starting to see difficulties in the reduced capacity or hybrid models that schools are implementing because that impacts or requires some intermittent leave issues where one day the kid may be home doing remote learning and the next day the kid is in school. And these create intermittent leave issues that clients are beginning to struggle with. I think the key is to plan ahead, communicate with your employees, and be willing to be flexible and creative as to how you're going to get around these issues. On the return to work front, as David said, the employees have to be returned to a same or similar position after taking this leave. Employers can require a negative test before returning to work. And you could choose, if an employee has been out due to a quarantine situation or they tested positive, if you want to take a precaution of putting them in a position that requires less interaction or even suggesting that they stay and conduct work remotely for a while longer, you have that as an option.
So, as many of you know, and I'm not going to go through this slide piece by piece, if you are required to comply with the leave provisions that are provided for under the Families First Coronavirus Response Act, then typically what is going to happen is you're going to get a credit back on your taxes for the dollars that you spent. There are some limitations. There's been some expansion of this through another executive order. So if you end up having to pay these additional wages, just that third bullet point is important to recall, is that you are going to get that dollar for dollar credit, and it's important that you speak with your accountant about how to manage this. Again, I know that a lot of this is review. I'm hoping it's review for all of you. If there are specific questions, we can try to get to them at the end.
All right, and David, just the key there is if your employee's making, $1,000 a week, and it exceeds what the act provides, and you choose to continue to pay your employee above and beyond the cap, you can't get the credit for that additional amount. You can only get the credit for the amount set forth in the law up to the caps.
Great, thanks, Jim. This is a question that we get asked a lot, and there are some questions related to it. So one of the things that we do want to point out, because there has been some changes, I think that most of you are probably familiar with this concept of this exclusion under the FFCRA for healthcare workers. And as you know, when we've talked about this in other presentations with you, the definition that was provided by the Secretary of Labor is very, very broad. It's here, but the reality is that under that definition, essentially all of your practices would fall into this. However, there's been some change and some guidance. I don't necessarily want to call it a change. There has been some guidance. So there was a recent New York case. Jim, if you can break that down for us a little, I think it would be very helpful.
Yeah, so what happened is that the law was passed in March. It went in effect in April, on April 1, and not more than 2 weeks passed before there was a lawsuit over it. And the lawsuit was brought by the state of New York, the Attorney General of New York, suing the Department of Labor. And the basis of the suit was that all the regulations that were passed, all 880 pages of it, that some of those exceeded the Department of Labor's ability to regulate. They have their ability to regulate is confined somewhat, and they basically exceeded their regulatory authority in 4 areas. The first is the exclusion of leave benefits if work is unavailable, and I'll discuss that. The second is the definition of healthcare provider, which is relevant to what David was just talking about. The third is employer consent for intermittent leave, and the fourth is documentation requirement for leave. So the New York challenged these 4 regulations that were passed in support of the law by the Department of Labor. So the work availability requirement, what the FFCRA said, if you recall, and it was very interesting, is that if there's no work available for an employee, then they aren't eligible to take this paid sick leave or the family leave, which, kind of makes a lot of sense. Like if an employee, if we have our receptionist and our office is closed and our receptionist is sitting at home with no work to do, why in the heck would she be entitled to take leave? If there's no work available, Department of Labor said, then you're ineligible to take leave. The New York District Court came in and said, nope. The way the Department of Labor did this was inappropriate and abused their discretion, and so we're invalidating that requirement. So now, even if work is unavailable, an employee can still ask for and receive either of the types of leave we were talking about. The second area was the definition of healthcare provider. And David had the definition up there, and it was very, very broad. The way the statute was written is the definition of healthcare provider was supposed to be taken from the Family Medical Leave Act, the one we've been dealing with for decades. So when the court looked back at that, they said, well, Department of Labor, you've really expanded that beyond what the definition is supposed to be. So it's overbroad, and we're invalidating that as well. And the only people who should be excluded under the healthcare provider are those individuals or employees who actually provide medical services for purposes of evaluating these leave requests. The third area, again, was interesting, and it said that the regulation said if someone wants intermittent leave, they have to get the employer to agree. And if the employer agrees, then the employee can take intermittent leave. And this was very unusual. But the idea was that employers did not, the Department of Labor did not want employees trying to come back early if they had a COVID-related health condition or they were a high risk of exposing others. So what the Department of Labor said, we want you, if you go out on leave, you have to use that entire period because it's 80 hours, 2 weeks. That kind of corresponded with the 14 days that employees should be self-isolating. The court agreed in part and disagreed in part. First, it said, look, no, we don't agree that you have to get prior consent. There's nowhere in the statute that suggests that's necessary. However, we do agree with the Department of Labor that if you go out on leave for qualifying reason, you have to stay out on leave until that reason expires. And if there's another qualifying reason later and you have 80 hours left, you can go, a portion of the 8 hours left, you can go ahead and take it. So for example, if someone goes out on leave because they don't have childcare for 3 days, they take that 3-day block under the paid sick leave, which would be 24 hours. And let's say that situation resolves itself. The employee still has a chunk of the 80 left, and 2 or 3 months later, they get diagnosed with COVID. They can still take that remaining chunk for that second qualifying reason. So the court sort of agreed that intermittent leave, you don't need consent, but you can take it. The final piece that the court dealt with was the idea that employees had to provide prior notice to document the leave, and the court just said, no, that's nowhere in the statute. What the statute says is that the employee must give reasonable notice for paid sick leave and notice as soon as practicable for the family medical leave, and that's the way we're sticking to it. So this August 3rd opinion, which came out about now 3 weeks ago, sort of gave some update and more context around the regulations. If you can flip to the next slide. So what are the takeaways now given this court opinion? First, at this point, those are the only parts of the final rule that have been challenged. So the rest of the 880 pages remains intact, including an outright ban on intermittent leave for some qualifying reasons. Again, this is just a decision of one court in the Southern District of New York, and it's unclear what authority that would have, for example, in Maryland or Virginia or DC or something like that. Technically, the court's authority doesn't go that far. It's uncertain whether any of this has retroactive applications. So far, the Department of Labor has not asked to stay or appeal this decision. The Department of Labor could issue some new regulations around these issues, and Congress could react. My own personal feeling is that this is going to just kind of stick. We have the election, and then this whole thing expires on December 31st. I'm not sure any of these issues will be flushed out anymore between now and then, and we'll just have some uncertainty. What we're suggesting is that employers, well, David, you go ahead. This is your slide.
So ultimately, what does this actually mean for you? What are you bringing back to your office and how you're managing? Ultimately, it means that there's still some uncertainty. It's hard to believe that anything could be more uncertain than what you've been dealing with, but I think that the biggest part that employers are going to want to deal with is this nightmare that is intermittent leave. That's allowing somebody to take off 2 days here and 3 days there. Do keep in mind it's only up to the maximum of the 80 hours, but it is a logistics issue for you in terms of tracking that. You should proceed as if the decision applies to us here in Maryland. So consider allowing intermittent leave, allowing an employee to take leave even if no work is available. We understand this doesn't necessarily make sense, but this is the guidance that New York seems to be pushing down. Don't condition leave on prior notice. And if you're a healthcare provider, keep in mind who you're applying these rules to. If it's somebody at your front desk, that may be different than one of the physicians or one of the mid-levels that's in the office. So return to work guidelines. Again, I'm going to cruise through some of these. These are great resources for you. Again, if you do have specific questions, we are happy to try to get to all of them at the end. But ultimately, there is a lot of good information that has come out. I think one of the best pieces of information I've seen is the FAQs that Jim mentioned from the Department of Labor. They are very detailed. They give a lot of very good examples. The CDC also has a very robust portion of its website that is related to COVID-19. OSHA has good information as well. We're going to get into some changes on back to work that have come out of the Equal Employment Opportunity Commission, that's the EEOC. And then Maryland also has good resources available. For you guys, you have an added benefit. The Montgomery County Medical Society has been on top of this, I think, better than most organizations. So that's probably a great place to start. You've got some very good resources locally. I don't think that there are a lot of trade groups out there that have the kind of resources that you guys have. Similar, these are just some links that we threw in here for you. So please go and check out what OSHA has to say, what the CDC has to say. The key takeaway from this slide is remember that what the CDC is offering, for example, is guidance. It is not meant to replace state law and local regulations. So do make sure that what you're doing still complies with what's being required in Maryland.
Yeah, thank you, David. Those are some of my go-to websites for getting up-to-date information on the recent guidance. The CDC, I assume everyone's familiar with, but the CDC has changed or updated their return to work guidance. The end of last month, they issued a document called Discontinuation of Isolation for Persons with COVID-19. Not in a healthcare setting, but if you look at it, it basically is the same thing for healthcare and non-healthcare. And what it's done is it focuses more on symptom-based strategies for determining whether someone should continue to isolate versus test-based strategies. So the criteria now, according to the CDC, for returning to work is that the individual should remain on home isolation for until 10 days has passed since the onset of symptoms for the first the onset of symptoms, or the first positive COVID-19 test, that at least 24 hours has passed since resolution of last fever without fever-reducing medications, that was formerly 72 hours, and that the other symptoms associated with the disease has improved. Formerly, it focused only on respiratory symptoms. So those are some of the changes. There are still caveats for severe and critically ill and immunocompromised persons. The data seems to suggest that these individuals may continue to produce the replication-competent virus for 10 to 20 days. So the CDC is recommending extending the isolation from 10 days up to 20 days. The CDC formally recommended discontinuation of isolation through test-based strategies, 2 consecutive lab-confirmed negative viral tests within 24 hours. Again, the CDC is moving away from these test-based strategies, again, for return to work guidelines. And now the CDC does not recommend test-based strategies unless you have a critically ill or immunocompromised person. You know, oddly, the CDC continues to recommend that individuals who have been exposed but are asymptomatic continue to quarantine for 14 days. Just a little strange given that, you know, as I was saying, they're recommending someone who's actually had the virus or tested positive self-isolate for only 10 days. The EEOC is also updated at the end of June, its return to work guidelines. And David, just quickly flip the screen here. They're really focusing on, go ahead and flip it. The cube is, okay. So they're focusing on a couple areas that have tended to be highlighted during this particular scenario. They're focusing on age issues, and I've had a few of these come up where I've been asked, can we get a waiver from someone who's older or something like that? And the answer is no. You can't treat people employees differently because of their age, even if they may be higher risk or something like that. If they come to you and ask for an accommodation, then we deal with it within the context of the traditional analysis of disability accommodations and things like that. But we can't treat people differently because of their age. We can be more flexible though. Focusing on caregiver and family responsibility, don't make, it's encouraged, the EEOC is encouraging employers not to make any gender-based assumptions about who may have caregiving responsibilities. They wanted to alert employers on pregnancy issues, that employers can't involuntarily exclude employees due to pregnancy, same kind of thing as don't exclude older workers just because we think they may be at higher risk in a particular situation. And to keep in mind that if you're giving accommodations to portions of the workforce, those same type of accommodations need to apply to pregnant employees, regardless of whether their pregnancy has risen to the level of being problematic or creating a disability. If you're allowing some workers to telecommute and a pregnant employee wants to take advantage of that as well, and their job can be done by telecommuting, you can't discriminate against that pregnant employee. David, you're on mute.
Some people say I sound better that way, but I guess not. So some of the things that we're recommending for people is that as you're getting ready to bring people back into work, the most important thing for you to do is plan ahead and communicate. That means communicating with your employees directly through documentation, and then don't stop there. Make sure that you follow the plan that you have in terms of implementing it, keep an eye on what's going on, and make sure that you're trying to stay flexible. Other things, one of the things that we flagged, I think we flagged it in another discussion with you guys, but do be mindful of growing vacation accruals and liabilities that you have with your employees, all right? So during this time, if you have not changed any of your leave policies, your employees may still be accruing vacation time. And that's something that's important to consider, because you'll recall from our earlier slides that whatever vacation rights they have in your practice through time that they've accrued is still going to be available. So you may end up in a situation where people have taken time off or haven't been charged vacation time because an office was closed. That leave may still exist, which means that it could have a financial cost to the practice for paying that leave. So we've encouraged our clients to look at what their vacation leave policies are, decide if they need to implement changes to the policies, even if it's only temporary, just so you don't find yourself at the end of the year with employees who have not necessarily been in the office working, or who have had abbreviated schedules but have not been charged vacation time for that time. And now you're facing a situation where you either have employees that are rolling over big banks of leave time, or they're getting paid out at the end of the year. Just something to think about. Also, for those of you who haven't opened your offices yet, or you're only going with a partial appearance of folks at the office, do give some thought to how the office is going to physically function when people get back. I think the most important takeaway, other than the planning component, is make sure that if it's possible, you have an access logbook so you know who's in the office and when.
Yeah, thanks, David. There's a lot of practical considerations to telecommuting. I don't know how many of your offices are continuing to telecommute or do telemedicine. We certainly recommend a formal telecommuting policy, and we have one that we can easily provide and help you roll that out. And it just deals with a lot of these issues that one may not necessarily think of when telecommuting. So why don't we just go ahead to the questions, David, start to dive in and help people with specific issues.
All right, so again, I apologize that we really wanted to cruise through those, but there were some significant changes that we thought were important to flag. We're going to start with the questions that we got ahead of time. So Jim, why don't you take this?
Okay, this question, if an employee works at a COVID facility hospital, what are the options? And I'm assuming here that, and if someone's on the call, on the webinar and wants to elaborate through the chat room, please do so. But I'm assuming that this is an employee who may want to exercise leave rights, and we walk through some of those. If it's a general anxiety to returning to work, obviously that is not covered by the leave laws, and we certainly get a lot of those questions from clients that employees are just concerned about returning to work, and that's not going to be sufficient to trigger the leave. However, if the employee has been required to quarantine or isolate, obviously that's going to trigger the 80 hours, the right to leave. Or if obviously if they have COVID symptoms, that's going to trigger the 80 hours. But just general anxieties or fear of contracting COVID are not going to be enough to give an employee the right to exercise the paid leave. They may want to exercise accrued leave that they have in their leave bank to take a period of paid leave. If an employer has an unpaid leave policy, may look at whether or not that's an option, and so that the employee can go on a unpaid leave status, maybe be furloughed or something like that. So there are a number of options. Again, the key is to sort of be flexible and creative, I think, with your workforce at this point in time. But there are not that many paid leave options here. There may be a number of unpaid leave options.
I think one other item to be mindful of here is what the guidance that Jim was explaining to us from the New York lawsuit is. If you're in a hospital or facility, do keep in mind the role that the employee is playing within the organization. There may be exemptions from having to comply if we're talking about a physician or a mid-level provider. Those exemptions may not exist the same if we're talking about someone who's more on an administrative level. So the answer, I think, is going to involve both the concerns that Jim's raised in terms of what leaves available, but also the role that the person's playing in the organization. The second question was, is the 80 hours of coverage, and we added in presumably under the FFCRA, is this a one-time only benefit per employee? The answer is yes, it is, but again, be mindful of the guidance about intermittent leave. So while an employee is only allowed to get their 80 hours paid once, keep in mind now that that may be incremental. It may be 2 days here or 3 days there. So that's an important factor to keep in mind. Jim, are you still with us? Looks like Jim may have dropped, so I'll take this as Jim's logging back in. It says, when physicians don't want to come into outpatient practices due to a fear of getting COVID, and they think that all the inpatient encounters should be delivered via telehealth, is there a risk of legal accusations of retaliation for terminating these physicians? This is a very meaty question. I don't think it was intended to be, but there are actually a lot of different components that I want to break down a little bit here. Generally speaking, a fear or anxiety, and this piggybacks on what Jim said about in the previous question, a general fear or anxiety does not trigger leave rights under the Families First Coronavirus Response Act, right? So if someone is nervous, that is not going to trigger leave. One of the interesting components of this question, though, is there's this piece about there possibly being a disagreement about how the practice is working because they think that there should be telehealth where other people maybe feel that in person. I only look at that because of this question about retaliation. If you have an employee that is complaining about some sort of protected right, then I do want to be sensitive to the fact that you could end up in a situation if the person says, well, I had a right to complain about this. I either had a First Amendment right or something like that, and I was terminated for that. So if the issue that the practice is dealing with has to do with the complaint about how the care is being delivered, I would handle that differently than if the concern is about COVID or a fear of getting COVID. Okay, so I think that those are important issues to consider. Again, we also want to be mindful of the other components behind it. The one thing that we would want to add to this is if you have an employee that has something beyond standard anxiety, right? Because I know I go outside and I wear gloves and a hat, and I try not to touch everything. I've used more Purell over the last 3 months, and I'm a Purell addict, and I've used more than ever. I'm happy that I haven't need to go see the dermatologist because of how much Purell I'm using. But if it goes beyond that standard concern that many of us have about contracting it or how careless other people are, and there are probably a lot of you out there that are like me and get agitated when you see people wearing their mask but it doesn't cover their nose. If it goes beyond that and someone comes to you with a doctor's note that says this individual actually has some higher level type of anxiety, you do need to be mindful if this gets into a situation where now somebody is possibly has a disability or falls under the Americans with Disability Act, and there may be a need for an accommodation, right? So don't just look at this as, that's why I said this is a very meaty question, a really good question, a lot of really good information to come out of it. So the three pieces of this to take away are, if it's just standard anxiety that we all have, that does not trigger leave under the Families vs. Coronavirus Response Act. If it is a retaliation issue that we're dealing with because someone has come to management and said, I don't think you should be seeing patients this way for XYZ, and then you terminate them as a result of that, we could be stepping into some legal waters that you would definitely want to speak with your legal counsel first. And then that last piece is, if this elevates beyond standard anxiety, then I want to make sure that you are being mindful of other legal obligations that you may have to the employee outside of COVID, outside of the Families First Coronavirus Response Act. Okay? I am going to see, it looks like Jim had sent me an email here. Let me make sure I didn't skip anything. Bear with me for one moment and see if I can't figure out what happened to our friend Jim. Looks like his internet is down. That's funny, only because at the beginning of the call, we all heard this terrible thunder outside. So I will, I'll see if I can't take the torch and run with it here. And if there are any really, really complicated questions or things that we get wrong, we'll all just agree amongst ourselves to blame it on Jim, right? Good, I see everybody's in agreement, so that's great. So where's the best source to hire new employees? I didn't quite understand this question. So I think this might be an opportunity for those of you participating in the call, if you've had an opportunity to be looking to hire people, and you have a suggestion that you can put into the chat box for whoever answered this question, that would be awesome. I'd appreciate that. So I'm going to jump to the next. How do I limit liabilities from patients suing me if they contact trace to someone that works at my office? This is a great question. This is an issue that a lot of our clients have been concerned about, particularly situations where we have actually had exposures. Fortunately, it hasn't been from staff, but it has been from other patients in the office. There are very, very protocol-driven ways in terms of how you respond to patients in a situation where you find out that someone may have contacted COVID-19 in your office. Ultimately, the best way to avoid this is to make sure that you are doing your best to comply with all of the CDC guidelines, hygiene requirements, PPE requirements. You know, I have a number of clients who actually don't use their waiting rooms anymore as waiting rooms. They have patients wait in their cars in the parking lot, which is challenging, and I certainly hope that they have air conditioning in the summer and heat in the winter. But you know, we do have a number of clients who have patients wait outside when the waiting room is empty and they can come do the registration. They call to the person in their car, they come in. The people at the front desk have been trained to make sure that people who are coming into the office are wearing masks, that they're wearing them properly, not getting on my pet peeve of the people who don't cover their nose. So the best way that you can limit liability that you would have from a patient coming after you is to make sure that you're doing everything that you can to comply with all of the guidance that's out there. Because I believe that if a case was to come up where a patient says, I contracted this at, you know, Dr. So-and-so's office, or I was in for physical therapy at this clinic and I know I came away with COVID from there, you have a couple things working for you. One, if you have done as the best that you can complying with CDC OSHA guidelines, I think that there is going to be some understanding that you cannot protect 110% from this, right? This is a very, very complicated, difficult virus to attack and to conquer. And I think that fact finders are going to appreciate that. The other component, which I think is a benefit, is it is incredibly difficult to trace exactly where somebody who is out and about contracted COVID. So there is, I think, going to be a very high level burden of proof on top of that. So the best I think that you can do is make sure that your staff is wearing PPE, make sure that we're wearing gloves and gowns and face masks or goggles. Some of our offices require their people to wear booties and hair nets and things like that. Depends on the kind of office, but that is the best way, because just, you know, what you see on TV, your staff is not just wearing the mask to keep themselves safe, they're wearing the mask to keep the patients safe as well. And I will tell you that in most of our client offices where I've been involved and I've heard of someone contracting COVID, it has not been from an employee. It has been from a patient who came into the office and either lied, or, you know, usually it's some, you know, emergency situation that happens. You know, we had an unfortunate situation where someone came in, they're having a hard time breathing, they needed a nasal cannula and oxygen, and they took off their mask, and, you know, that was an issue. So I think that I think that the best you can do is make sure that you are doing everything in your capacity to run a safe office. The next question is, if there is a known COVID-19 exposure in the medical office, can all of the workers work unless they become symptomatic? And then our front desk staff receptionists included as healthcare personnel in the CDC definition. I think we've answered that second piece. That is a direct takeaway from that New York lawsuit. We do want to be mindful of treating our staff and receptionists different from our healthcare personnel, our actual hands-on providers. You know, again, it's a case-by-case analysis, but certainly something worth looking at. The first piece, I think, really relates to the last question that we discussed. The answer is that if there's a known COVID-19 exposure in the medical office, I think that prudence should be your guide. Welcome back, Jim.
I'm back.
We missed you.
That's something that doesn't happen at live.
Well, I can't say this is much better. So I'm going to keep going as Jim. That's a great face. If someone can screenshot that so we can tease Jim about that later, that would be terrific. So I think that if you've had a known exposure and you're concerned that your staff has been exposed, I think you're going to want to look at either quarantine or testing, absolutely stepping up PPP. I think that if you have a known exposure in the office and then you are subjecting patients to that risk, I do think that you change the dynamic from the last question in terms of liability, because now we've got a known situation, right? So I think that once you know that there's been an exposure, you probably want to take whatever prophylactic and steps that you can take to not expose the, no pun intended, but not expose the business to greater risk. You know, and I will tell you that in my client offices where we have had exposures, we have given staff the next, you know, fortunately we've been able to track who was interacting with the patients, but we have given staff a couple of days with paid leave to go get tested, to quarantine, to make sure that they're fine. And we've been very, very lucky that there has been no further exposure from it or no further contracting of COVID-19. But let prudence be your guide here. Jim, are you with us that we can actually understand what you're saying? Well, better than we, at least as well as we could before? I'm going to take that as a no. Jim's all tight-lipped about this. So the next question is, can we tell employees that they cannot go to the beach or participate in any high-risk COVID-19 activities, for example, going to wedding, due to potentially exposing the office? And if an employee goes to a high-risk location and needs to be quarantined until tested, do I need to pay the employee? Really good question. The answer is, just because we employ someone does not mean that we can control every aspect of their life. Jim and I have a lot of employees, and sometimes it would be great if we could, but we also have confidence that our staff is responsible and respectful. We're in a little bit easier of a boat than you are right now because most of our staff is still virtual, but we certainly have had discussions with our core staff that is in the office about making sure that they are prudent. You know, it's fine if they need to go, you know, we understand people are going to take vacation. We understand that, for example, funerals happen and things like that. We have encouraged our staff to be careful, not so much because they can't be responsible for themselves, but we want to be very, very careful of what they're bringing back to the other core office staff. That's our primary objective, is to protect our other office staff. That being said, we can't tell people that they can't go on vacation. We can't tell people that they can't go to a funeral or a wedding because of the exposure. We may have office protocols, however, that say, under these circumstances, if you're going here or there, and this has been an issue for a couple of our clients, you know, if you're going to these places, you can't come and work in the office. You can either work remotely if that's an option, but we may require people to quarantine. We may require people to go get a negative test before they can come back. And keep in mind, if that situation doesn't fall within the paid sick leave, the expanded paid sick leave law items, that's that list of 6 items that Jim reviewed for us earlier on. If that doesn't fall within one of those items, they are not necessarily entitled to pay under the FFCRA, right? They may be able to use vacation time, right? But we're essentially telling people that we have these policies in our office and we need people to be mindful of the policies. And if you're going to go to these locations, we need you to get a negative test. If the employee is going to do it on their own, then it's certainly fine for them to use vacation leave if they have. The one item that, and I would be great if Jim was able to join back in, because it was an item that he was looking at in response to this question, was whether there would be an expectation or requirement for the employer to pay if the employer requires the negative test, right, of the 2 days. So if Jim doesn't join back up with us on this, we will certainly email Susan and Carissa the answer to that so they can forward that on to you guys. Okay, I am going to see, I think I need to release my screen here, maybe not. Let me see if I can bring up the chat element here.
Yeah, it looks like we've just had one question via the chat box so far, and that question is...
How do I see that? Hang on. Ah, wait, I see it. Maybe. All right. I'm a very visual person, so I want to be able to see it. Okay, I'm sorry, Carissa.
So the question is virtual school not the same as school closure under EFMLEA? And if we have an employee that needs to stay home to help teach her kids, but school is virtual, not closed, do they qualify?
That is a great question. I think that there are two pieces to this. Hey, Jim, are you back with us?
Unbelievable.
Don't worry about it. We are going to come back to you because we're going to come back to you after this question, because we were just looking at the last question that was submitted about the employee who needs to go to the beach for vacation and then they come back. And one of the questions that you and I had discussed on that is there a difference if the employer mandates that the individual not return to work for purposes of going to get a negative test versus if the employee says, I need to go and get this test and I'm going to take a couple days of vacation. So we're going to come back to you on that. Getting back to Joe's question here, the virtual school concept is a little bit confusing. So let me break it down. If your child's school is closed, right, your child may not come to school, right? In that situation, it would trigger the leave that is available under the FFCRA, okay? If your child, and this is again where this New York case is so important, and one of the reasons that we wanted to take time to talk to you all about it, if your child's school is in a hybrid situation where, you know, some kids are going to be there on Monday, Wednesday, Friday, the others are going to be there Tuesday, Thursday, and then they're going to flip and they're going into school and out of school, this is where we may get into these very, very complicated, very difficult for the employer intermittent leave situations. But ultimately, there's been no change in terms of the coverage for schools. The idea is if your child's school or daycare provider is closed, so your child may not physically go there, it would trigger the leave entitlements under the FFCRA. If the school is open and either you choose not to send your kid there or there's an option or things like that, it probably would not necessarily trigger the leave rights that come up under the FFCRA.
And remote learning will trigger it. So if the school is open,
well, that's because the school's closed.
If it's in remote learning mode and
Right.
an employee has to stay home, it will trigger the right to leave.
Yeah, I would agree with that. So Jim, it looks like that was the only question, although I see a different note. Give me 1 second here. So I saw a note in here and it says, should you apply for an exemption from EFMLEA before you would need it? So I'm not sure that I understand the question. I think that that is probably not the way that this would work. I think that there would be no need to go and challenge this proactively. I think it's really going to be an issue if someone is trying to seek the leave and you end up being in a situation where you need to deny the leave because that individual or because your office would otherwise be exempt. And do keep in mind, I think Jim mentioned this earlier, it is an unusual situation. I have not had any clients, and I've had some clients who've struggled through this. I've had some who've done phenomenally through this, but I have not had any clients challenge their obligations under FFCRA because they would otherwise be exempt. I think that was the question. Looks like Jim, you know, he knew the heat was on that question, so it looks like he's left us again. So let me see if there were other questions here. Chris, did anything else come in?
Yep, one more. So what's your advice about a two-physician practice in which one of the physicians, equal partners, is following the appropriate guidelines, but the other is not? How would you advise handling this situation?
So this is, I believe, you know, and you can see that's a Susan question. You know, that's, you know, thanks, Susan. You know, really tough ones there. You know, this may end up, ironically, this may end up being more of a corporate governance type issue than an FFCRA issue. However, I would have a concern if this came up. If it is well-founded and the person who is trying to follow all the rules has legitimate concerns that the other individual is exposing the practice to risk or liability, I think it would be the type of thing where you want to have a sit down. You probably want to have some documentation that says, these are the rules, these are the guidance, this is what the CDC is saying. You know, this isn't fake news, right? This is scientifically based, and we should be doing this for, and list off the reasons. We do this because it is important for our staff. You know, I mean, people ask, you know, we have attorneys at my office saying, why are we not all working back in the office? And we basically say, well, because we have a core group of staff there that is busting their hump every day to make sure that the office is running like clockwork, and we need to protect them. This is not about, you know, it's more convenient or it's more comfortable. I mean, of course, some people are going to complain no matter what, but you know, those people exist too. But that is what we are mindful of. We are mindful of doing what is important for our employees. We are mindful of doing what is important for our clients. We don't want clients coming in unnecessarily. You know, we have a very rigid protocol in place for clients that need to come in for a meeting, clients who need to do will signings, or ironically, in this time of COVID, there's been a tremendous amount of real estate activity. Those two departments, as you can imagine, are very busy. We have a very rigorous protocol that we've basically said, these are the best information that is available from the CDC and from OSHA, and this is how we're going to do it. If I had a partner who challenged that, the nice thing is I have enough partners that usually common sense prevails, usually. But if it's 50-50 and I had a partner that I thought was exposing the practice, I would probably need to have a discussion with our legal counsel, and I would probably want to make sure that I was documenting some of that. But I'm going to say this is a big but. Don't document anything before you talk to your legal counsel, right? You don't want to create this long logbook of how terrible our practice is and how we don't comply with anything, that then somebody sues you and you've got this very, very nice roadmap to everything that we did wrong, right? That's always something you should speak with your legal counsel first. I had a great question in a different seminar that I did. And it was, someone had asked whether or not they should have, you know, patients coming into the practice either sign waivers or, you know, some acknowledgement that there's an assumption of the risk by coming to the practice. You can see those might make you comfortable to have people sign off on something. And one of my colleagues in, you know, a think tank group that I participate in had a great comment, which is that it's great to tell your patients that you comply with all of the CDC requirements and all of the OSHA requirements. However, if you don't, you've now set yourself up for some new type of liability because you've told patients that you do. And so you need to make sure that you're really on top of it. So I know that's, you know, sort of a different type of situation, but this is a great question because it goes a little bit beyond the COVID-19 related issues. But I think it's really important in that type of scenario that you bring in your legal counsel. If you're not the person who deals primarily with the practice's legal counsel, call your own independent legal counsel, get some guidance, you know, reach out to colleagues that you have in the Montgomery County Medical Society community, see if any of them have small practices and how they've addressed these issues. But I would be concerned to just let that skirt by the wayside. It's easy to be a shrinking violet, but it's not always the safest option for your practice. And ultimately, it's about keeping the practice running, keeping your patients taken care of, keeping your employees fed and housed, and all those important things that you do on an everyday basis.
All right, so that brings us to our final chat box question, which is, how would you address an employee's complaint that working in the practice is causing undue stress and the employee is unable to perform his or her duties? What is your advice? How does this impact other employees who are in the same environment?
That's a great question because it is a practical, real life situation, and this is happening. You know, I don't know if there are counselors and therapists and people on the line, but you know, Certainly people who are mental health professionals are probably right now, I would say, busier than they've ever been. And I don't think that's going to change. There's so much unknown about the risks and the symptoms. I mean, every time you go online to try to find out, you know, this symptom or that symptom, there are 9 other situations that come up and new symptoms, and you know, now children can get it and dogs can get it. And there's a lot of unknown. So I think that the simple answer is that this tracks back to the discussion that we had earlier. General anxiety is not in and of itself something that the practice needs to make an accommodation for, and nor is it something that would necessarily entitle the employee to leave under the FFCRA, right? So I think that the guidance that came out of New York that Jim reviewed for us is absolutely on point. And the practical components are absolutely on point. I think we want to try to be understanding. We want to try to be flexible. We want to try to be compassionate. It does not mean that you're supposed to turn your practice upside down. If people have leave available that they can use to go seek help, they certainly should. Of course, that could be a two-edged sword if they then come back from seeking help with a doctor's note that says, you know, this person is entitled to some reasonable accommodation. But those are the responsibilities that we have as employers. If they come with a note saying that we're entitled to accommodation, reach out to your legal counsel and find out what is a reasonable accommodation. Not everything falls into that category. I know Jim deals with our clients on this all the time. What type of accommodation needs to be made? What type doesn't need to be made? But this is a very difficult time, and it is not your place as the employer to say what fears are rational, what fears are irrational, what fears are well-founded, what fears are not well-founded. I think that all you can do as the employer is say, this is the job description, and I'm going to have some flexibility. If you need to take time for this, you know, if they don't have paid leave available, maybe you can talk to them about unpaid leave to go get care that they need. They may have some leave available either under vacation or the Montgomery County earned sick and safe leave. So this is something that I think is going to be a very, very case-by-case review that you should do, and don't do it alone. Call your legal counsel, go through the situation, make sure that you're not stepping on anybody's toes, but anxiety, general anxiety in and of itself is not necessarily something that is the responsibility of the employer.
David,
Right.
Also, if I can,
Please.
I guess, earn my keep in the
Nice
last
to have you
30
back,
seconds
Jim.
here. If you have an EAP program, you can use that as a resource.
That's an outplacement assist, or that's a employee assistance program.
Right, and many times your healthcare carriers will have EAP programs provided as a package benefit. So I would encourage you to refer your employees to EAP. What I'm finding is most of our clients are trying to be creative and flexible, thinking about these things up front. Certainly in the medical profession, you have greater concerns because of the necessity of close contact with many patients. So making sure that all the PPE issues are addressed, making sure that the employees are feeling as comfortable as possible. I know clients who are doing occasional surveys to get an assessment of how their employees are feeling and what anxiety levels are being exhibited throughout the workplace. I think the question said not only with respect to one employee, but if that's permeating in the workforce. So there's a lot of data out there right now about staying in touch, communicating, doing surveys, trying to look around the corner and see what things are going to make employees anxious, addressing them ahead of time. If it just can't be addressed, then looking to the EAP programs or being creative and flexible with leave. Ultimately, you have some flexibility. If you want to draw a hard line in the medical, in your field, if it's a healthcare provider and falls under the definition of the exclusions, you can tell the employee that it's just tough, that you're excluded, we can't give you leave, and you need to show up. But I don't think many clients are heading in that direction, at least not the many that I've spoken to.
Now, Jim, Carissa, before I turn this back over to you, Jim, I wanted to circle back. There was this question about the employee who goes off on a holiday fling to the beach where everybody is coughing and sneezing coronavirus left and right, and they come back to the office, and there's this question about, you know, whether if they then take 3 days of leave when they come back, you know, does the employer need to pay them? So the real distinction that we had in this piece of it was, you know, whether this was some quarantine that was covered by the FFCRA, right? Because people remember on our list under the paid sick leave law, on that list of 6 items, there are some quarantines that are required by state order, or there's some testing that may be recommended by a doctor. If those things are there, there may be some entitlement to pay under the paid sick leave law. Then the question was, when they come back, if they on their own say, I went somewhere and I'm going to take a couple days, and they have vacation time, that's fine, you can pay the vacation time. The question was, if the employer mandates that they go get the test because of where they've been, because of a employment policy, do you know if the employer has to then pay? Now, I'm going to give you a freebie here, because if you don't know the answer, you can just pretend that you've frozen and we'll all buy it. Oh, well, you can't go and smile then, because now we all know that you're in. Oh, there you go. So
yeah, well, no, I mean, look, first of all, as an employer, you can restrict where your employees are going. If there are hotspots and you tell them, look, you go to the beach, you're going to have to come back in quarantine before you return to work. You can do that. You want to be careful that you aren't discriminating in any way against certain groups. But you can do that. You can.
But you don't want to say if you go to Guatemala, you can, you know.
Yeah, yeah, that's exactly right. You want to be careful about that. But generally speaking, you can restrict that, at least in this context, that off-duty activity by the employee. Say, look, if you're going to go to the beach for the weekend, we need you to come back and you need to quarantine. That is not something that is protected by, you know, these FFCRA statutes. That's something the employee has chosen to do. If you say you have to get tested before you return to work, and it takes 2 days for that test to return, that is not something that's covered under these leave laws. So if the employee did not have any other leave to apply, it's not something that you would have to grant them FFCRA leave. It could be unpaid. So you have to separate sort of the voluntary off-duty conduct by the employee as opposed to some mandated quarantine by the state under a public health order or the government under a public health order.
Great, thank you. And with that, Carissa, I'm going to turn off my screen here, my screen share, if I can figure out how to do that. And then I will turn this back over to you. Might be easier said than done.
You're good to go.
And that would be for Susan. So thank you all for joining us for the Jim and David show. I just love
mostly the David show, but
I love the way that the two of you play against each other and have a lot of fun. So, and that's important because these subjects can be very dry, but you always make it interesting. So we want to thank Paley Rothman for joining us tonight, and we appreciate your friendship and your collaboration. Want to remind all of you that we will make this webinar available online via our YouTube channel. Don't forget to subscribe to our channel because there's a lot of other great educational content there. I just want to remind you of just a few things. One thing that I put in this chat is that be looking for our rollout of a new staffing program. This will come soon after Labor Day, and we have 2 different vendors who can help you with your staffing needs, and we really hope that that will be helpful, especially in this time. Some event reminders. We're doing an early career COVID-19 kids and cocktails. Obviously, the challenges of raising children, educating children right now may require cocktails. And so we are scheduling that where we'll talk a lot about what are the practical solutions and challenges that you're facing right now. We're doing a Women in Medicine red dress and red wine event in September. We're also, of course, going to have some breakout sessions about how COVID might have impacted women physicians especially. We're doing a general membership meeting on October the 22nd, as noted on this slide, and that's going to be virtual as well. And we also just want to remind you that MedChi continues to coordinate weekly CME-accredited calls with Dr. Howard Haft of the Maryland Department of Health on COVID-19. And you can register if you just visit our website, montgomerymedicine.org/COVID-19. So with that, we thank you all for joining us. We look forward to the next time that we see you. And please make sure that you send any further questions to us. And also, I'm sure that David and Jim would be happy to answer those. So thank you so much for joining us, and we hope you have a good night. Thank you.
Good night.
Bye-bye, everyone.
Bye.